We move to allow the evidence be admitted and shown to a jury as the fire investigation completed was a continuation of the initial event and was completed in a reasonable amount of time. In the matter of Michigan v. Tyler, it was determined that no Fourth Amendment violations were committed upon the fire department's entry and removal of evidence. This case states in part, a building burning clearly presents an exigency of sufficient proportions to render a warrantless entry reasonable, and, once in the building, to extinguish a blaze, and for a reasonable time thereafter, firefighters may seize evidence of arson that is in plain view and investigate the causes of the fire. While a reasonable amount of time has not been expressly determined by any court, the fire investigation in question was initiated on the same day that the fire occurred, and the house had not yet been secured by the homeowner. The defendant's attorney will request that the evidence be suppressed under the exclusionary rule due to the chain of custody refers to the process of maintaining and documenting the handling of evidence. It involves keeping a detailed log showing who collected, handled, transferred, or analyzed evidence during an investigation. As a fire investigator on scene, having arrived in a reasonable amount of time to complete the investigation and therefore legally permitted to be on the premises, the chain of custody remains intact. Moreover, the Supreme Court has identified several exceptions to the exclusionary rule, one being the matter of inevitable discovery as seen in Nix v. Williams. This exception states that improperly seized evidence may be admitted under the inevitable discovery doctrine if the evidence would have been ultimately or inevitably discovered by lawful means. In other words, had a warrant been requested and obtained, the evidence collected would have been found during any routine fire investigation as it was in plain view. The plain view doctrine suggests that objects in plain view may be seized by an officer legally present if they believe the object to be contraband. In this case, the burnt object behind the television and the pour pattern suggested arson and were at that point considered to be contraband. In summary, allowing the evidence to be admitted and shown to a jury would neither violate the defendant's Fourth Amendment rights or the chain of custody. Furthermore, the Supreme Court has named exceptions to the exclusionary rule, which we have determined apply to this matter.